Hi, I'm Steve. You are you. Welcome to Digivice. Today we're talking to Ben from Xuveo. He is a solicitor and is going to talk to us about contracts, privacy, the Spam Act, and a number of other legal topics. Hi, Ben.
Hi, how are you going? My name is Ben Thorn. I'm a commercial lawyer. I run my own firm, and today I'm going to be covering some of the legal issues that have come out of COVID-19, particularly for small business and with a sort of a consumer law angle. So I think the first thing to start off with is that just a disclaimer that this content is general information only. It's not intended to be legal advice or professional advice, so you should seek your own specific advice for your circumstances. And bear in mind that everything that we cover today potentially can change very rapidly. Governments are pumping out information, and there's lots of legal changes that are happening at the moment. So lawyers are quite busy trying to keep on top of it, but definitely speak to your advisors, get professional advice when you need to, just so that you can be confident you're covered as best we can. So I think moving on from that, I think probably the first issue I was going to look at was just some general consumer law issues around contracts, and particularly how the current situation is impacting upon contract law. So with particular issues, the ACCC has put out a lot of information as well. So I'd recommend checking out their website. They've got some really good information about basic consumer rights and businesses, what you can do in certain circumstances.
I'll link it below as well.
Yeah, I've done up a PDF today actually of lots of these sort of websites that I might refer to, so that can be circulated at some point as well. So generally the ACCC's position is that the consumer law does still apply. There's no getting out of the consumer law in this. Just because it's a pandemic, just because there's an emergency, doesn't mean that consumer law suddenly stops applying. So for things like your statutory guarantees, which apply to all consumer goods and services transactions. So if a customer buys some goods, the goods are faulty, the consumer is still entitled to a refund, even though there's a pandemic. Same thing with services. If the customer buys a service from you, there's an expectation that that service will be delivered in a reasonable time frame to a reasonable standard. So those sort of things are things that you can't contract out of, even if there's a disaster or a pandemic, as we have. ACCC has come out with some specific information about cancellations particularly, so definitely check out the website if you're in that category. The general guidance is that if an event or a service, so for example travel, concerts, those kind of events, if your event is cancelled by the event provider, then generally the expectation is that a refund or a credit needs to be offered to the customer. There are some specific industry codes around things like theatrical performance events and those things, but the general expectation is that a refund should be provided if the provider cancels the event. If the event's cancelled due to government restrictions, there can be some change to that general position. So again, it's probably worth checking your terms and conditions carefully about what might apply in that situation.
Just going back to services for a second, I've heard of a couple of different providers who they've had clients come to them and they've said, look, we're going out of business, can we cancel our service for now? And the service providers pretty much said, well, you're contractually bound. You can't cancel that contract. What legality? What can we do if we're facing that situation?
So that's the next point is if the customer is cancelling, then that can be, in some situations, that can be treated as what's called a change of mind. So in that situation, the customer is not necessarily entitled to a refund. because the customer is cancelling rather than the provider. So that's where you'd look at, what is the particular circumstance in which this cancellation has arisen, and basically who's doing the cancelling. Is it the provider or is it the customer? So for a change of mind, definitely you have less rights generally than you do if it's not a change of mind sort of situation. So you'll see of late, most of the supermarkets now that used to have satisfaction guarantees and change of mind policies around returning goods you've decided you don't want anymore. Most of the supermarkets and retailers are now stopping those policies to, one, to counteract panic buying, and two, as well, because they don't want to run on having to refund and things unless they absolutely have to. So in those situations, if it is a change of mind, then the service provider can be within their rights to refuse a refund in that situation. The ACCC is sort of recommending that people be sort of compassionate and understanding in these circumstances, because there's a lot of things that are just going everywhere. So in that situation, have the conversation, try to negotiate something. You may be able to negotiate a suspension or a deferment of payment or something like that can get you through the current period. So that's something that can be worked out.
And I think people will remember that as well.
Oh, absolutely.
I think that's a big takeaway there, that even though you don't have to, you have the legal right to hold on to that contract, hold that person liable, if that's the right terminology. But people will remember that.
Yep, absolutely. And goodwill is a thing. And businesses in this situation probably need to be working to ensure they retain as much goodwill as possible. So burning off customers, might not be the best approach, commercially speaking. The other thing on that point is with subscription services. It's important if you're providing a subscription service. So the common thing is like a gym membership, for example, that's paid on a monthly basis ongoing or a periodic basis. The ACCC has specific information on gyms, for example, but if you're providing that kind of subscription service and you get to a point where you cannot actually provide the service that the customer's paying for, in that situation, the ACCC expects that you would be able to either defer the term of the service, so extend the length of the contract, or offer a refund for the period they can't use the service. So again, that's an important thing if people are out there providing subscription type services in that situation. So I think, and generally just with contracts, a lot of contracts have what's called a force majeure clause or an uncontrolled events clause written into them. So read those carefully. In some situations, that will allow the parties to suspend the contract for the period by which the flow of the contract is disrupted. So, and again, you'd have to read the specific clause to work out when it's triggered, what happens, who's got the rights, and in terms of payments, what sort of happens with that relationship. The other thing to look at is the doctrine of what's called frustration, which means if a party is just completely prevented from performing the contract, that can give rise to the ability to terminate on that basis. So that's with things like, you've booked an event, you've got a concert you've got tickets to. Obviously, the concert's not going ahead anymore. Can that sort of depends? Again, it's down to negotiating the circumstances. But if the solution provided can't be reasonably agreed, then that may give rise to a termination.
I've noticed that Eventbrite is not offering refunds; they're offering credits.
Yep.
So that's one way that they can event-based companies can get around that.
Yeah, and lots of travel providers are doing the same thing, like Qantas and Virgin and so forth have decided to say, look, if you've voluntarily cancelled a flight, we'll give you a credit voucher that you can use within 6 months or 12 months or however long it is. So in that situation, that's, you know, at the same time though, it's important to recognize there, if the solution you're offering is not reasonable or not, you know, it doesn't have to be necessarily convenient for the customer, but if it's something that doesn't fit the customer, then they may still have the right to claim a refund, even though you're offering them a voucher. So that's just something to be careful of as well. I'm just going through my notes here. The other thing to check, I suppose, with contracts is insurance. So travel insurance is a big one for any sort of travel related stuff, but for businesses as well, check your business insurance policies, both if you're the customer and also if you're the supplier, because you may be covered under your insurance if you have to give a refund or a cancellation. You know, so that may cover you. Just, of course, check your terms and talk to your brokers and so forth. What else have we got here? That's probably all the contract law sort of things. The other thing just related to that is there have been some changes in insolvency law at the moment, particularly around creditor statutory demands and bankruptcy notices. So the federal government is moving, I think it's been enacted by now, but it may not, but there's been announced they're going to lift the threshold for a creditor statutory demand up to 20,000 and give the debtor 6 months to respond, whereas currently it's about 28 days or 21 days, I think. So that's something to bear in mind if you're seeking to enforce a debt against someone, is that it's now much harder to bankrupt someone in the current situation. And also with that, there is for contracts entered after the 1st of July 2018 with a company, if the company goes into voluntary administration, then it might not be possible to terminate or exercise a right under the contract as well, due to some changes in the Corporations Act from July 18.
So what do you mean by that?
So there's different forms of insolvency. One is called a voluntary administration, and that is essentially where an external administrator is appointed by the company, and they attempt to continue running the business, or continue running it so that it can be sold to a creditor. So that's usually a preliminary stage of insolvency. In that situation, a contractual right under a contract, say a lot of contracts have the right to terminate for insolvency. So that right is suspended while it's in that VA period, unless you go and get court leave and there's processes around it. But just because someone's announced they're going into voluntary administration doesn't automatically give you the right to terminate a contract if it's entered after 1st of July 2018. If they go into liquidation, which is the stage after that, where the voluntary administrators decided, no, this is not going to work, we can't sell it, there's too many debts, whatever, they can put it into liquidation, which is more serious. That's the winding up stage of call in all the credits, get rid of all the assets and deregister the organisation. So once it's in that stage, you may have more rights there. But again, if you're thinking of terminating a contract, it's probably best to get legal advice on that before you do, just to make sure you're covered in your situation.
And you certainly don't want to go through these situations, but it's important to know what your legal rights are around this and what's changed.
Mm-hmm. Yep. And I guess the other thing at the moment that's sort of in discussion amongst, it's more of a state government issue, but federal government's making noise about it as well, is the whole tenancy arrangement, both for residential and commercial tenancies. There's talk about the 6-month moratorium on evictions. Probably stay tuned on that space if that's your situation, because the details are still being sort of worked out at the moment around who's going to have rights and do what, and how that's all going to work. So that's something that's still evolving at the moment. Cool. So just moving on from the sort of contract law issues, I was just going to look at some privacy as well. If your business is bound by the Privacy Act, so this is over, I think it's 3 million threshold turnover, then you're automatically bound by the Privacy Act. As well, if you deal with sensitive personal information, so medical information is one of those categories of information, then you can be bound by the Privacy Act. So generally, if the Privacy Act applies, there's the 13 Australian privacy principles that will apply to your business. Check out the privacy website, oaic.gov.au, has all of that in neat package form. But basically, the principle with this is we've got to be careful of what information you're collecting in your business, how you're storing it, how you're using it, and who you're disclosing it to. That's the basic principles of privacy law. So if you do collect information, make sure you do it carefully and, only collect what you need. So at the moment, there's some specific issues around medical information around if I have a staff member who contracts the virus, how do I handle that situation? Who do I tell? I have to tell my staff, I have to tell my customers, anyone who's been in my workplace, how do you handle that sort of situation where you've got, a staff member or a customer or someone that's been in contact with your business and they've, notified you that they've been diagnosed or suspected of diagnosis. In that situation, that is medical information, so the fact of the diagnosis, and you do have to be careful about disclosing. You shouldn't go out naming people unless it's absolutely necessary that you do that. So again, in that situation, just be careful and take advice on how to handle that. The Australian Privacy Commission does have actual specific information on that particular issue as well, so check their website for that.
It's also important to keep in mind the Spam Act as well.
Oh, absolutely.
I've noticed that usually I get a lot of emails from overseas, but since this has started, I've started getting Australian emails as well, emails from Australians who I know who they are, but I've never really given them my email address, which does actually breach the Spam Act.
Yes. So again, the law still applies. The law hasn't been suspended here. Just to backtrack a little bit, spam law basically regulates any form of electronic messaging. So email, instant message, so like your Facebook Messenger type, SMS as well, and telemarketing goes into your phone calls, although that hasn't really been a problem. I haven't seen any rise in people calling me. So if you're sending emails, text messages, instant messages, and they have a commercial content or promotional content in them, so if you're making advertising, promotions, offers, any sort of commercial marketing kind of thing in nature, if it's of that nature, then the spam law still applies. The point there is that the three thing basic principles apply there. So make sure you've got consent. So has the customer said, yes, I agree to receiving marketing messages from you? That can either be expressly by signing a form and ticking a box on your website, or signing up specifically for your newsletter, or you can get consent through your terms and conditions of sale. Be careful with that. The second issue is that all your marketing messages need to have a method of contacting you. So your address, your email, website, some way of contacting you. And the third thing is they must have an opt-out. So for a text message, usually that's you text stop to a certain number, or emails as an unsubscribe link, or you can reply and say, I'd like to be off the list. So those are the things. Recent cases, Optus got fined over $500 million, I think it was. I don't know, maybe it was 500,000, sorry, for breaches of this sort of thing where they send out messages and didn't have the right unsubscribe facility in place. So it is important. Consumers can complain to the So it's not Privacy Commission, it's ACMA that regulates this. So consumers can complain to ACMA if they receive too many spam emails from you. You might get an angry phone call. Again, it's about maintain the goodwill with your customers. It's a fundamental thing. People don't like spam. I mean, I've got dozens and dozens of emails about COVID-19 that from businesses that I've not really dealt with. So the general tip on that is, if you are going to send out a service message, that isn't necessarily spam, unless it contains those sort of marketing elements. If it's actual information about something that the customer is actually purchasing from you, so you're updating them to say, hey, delivery might be delayed because this is happening. That can be a valid service message, which isn't classed as spam. But again, try to target your customers there. Don't just send a blast out email to every single customer you've got. Have they actually got an order with you? Are they actually doing business with you right now? Those are the sort of things to think about before you go sending out broadcast messages like that. So that's something to think about. I think we all know that every business cares about COVID-19, and most businesses are taking steps to address it in the ways that they can. So I think generally with that, say only as much as you need to, and think about, if you've got your website sorted out, put something on your website and direct people there if they need all the volume of information, rather than sending out hundreds of emails. Okay. Other privacy concerns, there's been a bit of, as everyone's sort of moved into this remote working environment, there's lots of people using Zoom and Skype and all those sort of platforms to hold their meetings and to have just general chit chat with their office. There's a few things you need to consider with that from a security perspective as well. As well with privacy, if you are discussing client information, I mean, I'm a lawyer, so I have heightened obligations with confidentiality and protecting client information, as do most other professionals like accountants and so forth. So with that, if you are discussing client information, remember that it's confidential. Second is be aware of it, and try as best you can to ensure that the platform you're using has appropriate privacy mechanisms to secure that information. So things like screen sharing can happen. People can take screenshots. People can record the session. So if you're hosting, you get the recording, but it's possible to record it. So just bear that in mind. There have been a few instances, particularly with Zoom, where people have done what's called Zoom bombing, which is where they manage to hack into the meeting. And there's some specific tips around how to protect your Zoom sessions against doing that. And things like having a password on the meeting and so forth.
There was an article recently that I briefly looked at where the CEO of Zoom wasn't really expecting there to be this pandemic. I mean, no one really expected it. And so there's security issues that are coming up that they haven't really considered.
Yeah, oh, absolutely. And I think the problem of Zoom at the moment is more that they've suddenly had this massive influx of people starting to use their service, and Zoom wasn't necessarily designed for that. It's it's great for consumer stuff, it's great for chatting with your friends, but business grade level conversations where you're handling client confidential information, you're talking about sensitive business information, those kind of things, not necessarily what the platform was intended for. So things like their privacy policy, there's been a lot of talk about that, and just having the thought process around where could this information go, who has access to it, how is it controlled, is it encrypted? I'm getting a bit into IT here, but from a legal perspective, if your client confidential information gets breached, that's your problem. So if my client confidential information gets out on the internet somewhere, that's going to be me ringing the client saying, oops, your information's out there now. So that's a problem that any professional business that has clients that deal with that sort of information is going to need to be very careful about. As well as there's issues with, because we're working from home, we're often using the family computer, the family laptop, the iPad that the kids use, that kind of thing as well. It's important to consider those sort of security issues as well, about making sure that your device that you're using is secured properly, and it's got all the latest software updates and patches and things, so that it makes it harder for things to leak. What else have I got in here? I think just some general things, like the way I've got my Zoom set up is by default my webcam is off and my audio is off. So learn how to set that up properly. That way you're not accidentally caught in a compromising position. I promise you I'm wearing pants, but I've seen plenty of videos on the internet where people have been using Zoom without pants. So things like that, just be mindful of what's your background environment. Are you going to have kids racing through the back? It's sometimes unavoidable. But basic things like, are you wearing pants? Is definitely something to think about. And also be mindful as well, if you're screen sharing, watch your browser tabs. Close off before you start your session. Close off any documents or any web browser tabs that you're not going to use in the session, just in case. Again, it's down to obviously there's some questionable things people look at on the internet, but also if you've got a document open that's got client information in it and that somehow accidentally gets onto the screen share, then that could be a data breach that you need to manage. So just be careful with that stuff.
And that's probably the important part. It's funny if you do have an embarrassing moment, but it's more important to close down those tabs, because you may accidentally forget to close a client file.
Yes, exactly. And also your workplace policies still apply when you're at home as well. So just be mindful of any policies or procedures that are in place with your employer. They still owe you a duty of care even though you're at home, so they're responsible to make sure you're doing the right thing with that sort of thing. And the other thing, just generally with video, obviously people are new to this technology. Lots of people are new and struggling with it. Be mindful of that, sort of help people out where you can, and just bear in mind that sometimes the conversation might be difficult if you're taking advice or giving advice or taking instructions from a client over a video link. Bear in mind that maybe half their brain is going, how do I make this thing work? How is it not going to crash on me? So I think those situations might need extra care, especially if the information going across is important. So think about, do I need to confirm this with an email? Do I need to send a summary at the end? Those kind of things. Cool. And otherwise, if you are recording the session, make sure you tell your guests on your session that it's being recorded, just so that it's one of those surreptitiously recording sessions is probably not a good idea, generally speaking.
And this, of course, is being recorded for the specific purpose of sharing it on Facebook so that everyone can benefit.
Yeah, but basically just be clear about what's the intention of this meeting and how's it going to be used. Okay.
Awesome.
So there's quite a few things to think about there. I'd really encourage people just to go to the government's websites. They've got a lot of information out there that's, it is changing day by day or minute by minute in some cases, but certainly stick with the government websites because they do have a lot of good information, just general principles and some specific information related to this. And of course, if you do get yourself into a particular situation, make sure, seek out some advice. Lawyers are still open, accountants are still open. tax advisors are still open. Go seek out that professional advice for your specific situation. Some of the government information can be a bit hard to comprehend. So lots of professionals are spending lots of hours reading through the finer details of these things so that they can provide advice to their clients about these things. So yeah, definitely go get advice if you need it.
Yeah, and at least sticking to those government sites, you get the facts rather than someone's opinion.
Yep. Absolutely. I mean, some of the media can, some of it can be blown up a bit, but ABC is a generally good source at the moment. They seem to be presenting things fairly neutrally, and sometimes that can help to just sort of simplify and break down things. But definitely, government sources is the best information at the moment.
Great. Okay.
Cool.
Anything else to add, Ben?
No, I think that's probably everything I've got on my list of things to cover. But as mentioned, if you do have a specific situation, go get advice on it.
Absolutely.
It's probably the best bet at the moment. Everything's changing so quickly. So
yeah. All right, great. Thanks for your time. I took a bit of a back seat on this one, but you're the expert. I don't know much legal, so it was better for me to shut up.
Thanks, Steve. No, thank you for having me on, and it's great to sort of just cover a few things and do my own research, make sure I know everything I'm supposed to know. So but we are working hard. Lawyers are working hard. The law societies are working hard as well to support us all, and so we're trying to do our best to support the community as well in what we do.
Lovely. What do you think of? I was reading the other day. There's a drive-through legal practice now.
Yes, they're actually suggesting this for things like signing wills and stuff, where you actually have to have a physical signature on a physical document. That is one of the suggestions that's come out, is having this drive-by sort of arrangement in place. It's lawyers we're very traditional sometimes in our business approach, and so this is throwing a few curveballs here and there with having to change how we work as well. So it's fun times, and certainly we're getting, professionally speaking, we're getting lots of warnings from our insurers and our law societies that sort of saying, watch out for this and watch out for that, and here's what the land titles office is saying about how do you submit your property transactions and so forth. So we're copying a lot of information as well about those kind of things.
Yeah, of course. Yeah, so paralegals will be saying, would you like an advanced health directive with that?
Yes. Yeah, absolutely.
That's terrible. All right. Thanks so much for your time, and
no problem.
Have a great day.
Thank you. Thanks, guys.